Members of the jury, you have heard during the course of this trial a number of motions and objections, and the court has had to pass upon them. That is on the law side, of course, and you are not to mold your mind according to the decisions the court has had to make. I have told you before, and while you are before me, I will have to reiterate that you are here for the purpose of being judges of the facts. During the course of counsel's summing up, I said, rather than passing upon something that was disputed as to the facts, that your memories were paramount, and I can do no more than what I said then, unless with elaboration. You are not to mind what counsel says, unless it stimulates you to revive an impression of what has been said on the stand. You are not to mind what I say with regard to the facts to which I allude. I am simply here for the purpose of advising you as to what I deem necessary regarding the law. Counsel are zealous. They have a right to be. We all have our idiosyncrasies, our peculiarities, our vagaries, our individuality, and you must not feel that this is a delay between the court and counsel, or between one counsel and another. The highest function you can assume to look into the merits of the case, irrespective of what has been done before you, and I do not make the suggestion because of anything that occurred here, except that now and then there were so many objections made that you might have become a bit irritated because counsel thought that he had to make so many objections. I am saying to you, erase those things utterly from your minds. There are two litigants here, the plaintiff and defendant, and they have come here for a square deal. They are going to get it anyhow, and that is the job that you have before you. As I had to say before to a jury, after they disagreed, we cannot do more than take the great probabilities that there are in a case. If we are going to demand absolute proof, we cannot get it even if we are taken to the scene of the accident and have it done all over again, because witnesses utterly honest came here with different stories. If all of you saw an accident outside this court house or inside it yesterday, it would not be possible, according to the philosophy of the frailty of human nature, for all of you to be on all fours with others with regard to your story of it. One sees one side of it intensely and the other side is subordinated. Another sees another side with vigor and the rest is in the back of the picture. So we may be utterly honest and speak about that board and yet disagree with someone who is absolutely honest too. You know the way to judge whether the people are telling the truth or not, either consciously or unconsciously, and you are brought here for that reason, because we suppose that you are contaminated with the law and with the technicalities of it. You are here as men from the outer world, and you can pass on facts. What is expected of both the plaintiff and defendant is reasonable care. The woman getting out of the car should be careful under all the circumstances that surrounded her that could be brought properly to her vision. We understand that it was not daylight, it was rather dark. How dark, I do not know, but it happened in March somewhere between 7:30 and 8 o'clock. The party came from a restaurant not far away, and the two men got out, and this woman stepped out of the car in the way she told you. She could not stand up in the car. She put her right leg out, as we all know well, and then she got out of the car, and we can understand what the flexibility even of a stout woman who is getting out of a car, of an aperture, such as a doorway from a taxicab, is. She pushed herself out in the way she displayed here on the stand, and she fell. The question is, was it altogether her fault, or partly her fault, or altogether the fault of this hotel that placed this plank upon this pipe? What was that plank put there for? With the care that should have been used to give a passenger getting out of there, duly invited, having the right to get out of there, a safe place to alight? Yes, you have heard the plaintiff speak about this plank and the crack in it. You have heard everybody talking about the crack in it. It is true that plank was not broken. No matter who says so, we can go that far and say it was not broken. You have heard about the cleats. You have heard about its size, its thickness, and that at the end there was a split or a crack. You have to take all those circumstances into view. $175. How's it?
Pretty good.
Last one coming up. Ready?
Ready.
This action is here, ladies and gentlemen of the jury, because of the alleged negligence of the defendant corporation, the owner of premises in question. It appears from the evidence that the defendant is also the owner of the adjoining building. The plaintiff says that while the infant John was visiting his aunt, the boy sustained the injuries which have been made the subject of testimony here. The various claims of these plaintiffs are denied by the defendant, which states that it may be true the infant has sustained physical injuries and that the father has been put to some expense, but it is not its fault, the occurrence being due to either the fault of the infant himself or others under circumstances over which the defendant had no control and which it could not reasonably have anticipated would happen. Each side has presented evidence, and the issues of fact raised by such evidence you gentlemen are now called upon to determine. Under our system of the trial of cases, we divide the functions of court and jury. We, as it were, set up a barrier between the court and the jury. We say that the jurors are the judges of the facts. Nobody has a right to invade that province, not even the judge presiding in a case. And the judge is the one who expounds the law that is applicable to the case. As to the facts, you are to be controlled by the evidence and exhibits that have been received and marked in evidence. You are not to go outside of the evidence, nor to speculate by conjecture as to how anything may or may not have happened. You are bound by the evidence as you heard it from the witness stand. You are not to take any statements of fact made by either counsel as true, and equally important, and perhaps more so, you are not to take any statements of facts made by the court as true, because, after all, as I understand and indicate to you, dividing the functions of the court and jury, the judge under the laws is not permitted to have an opinion upon the facts in a case. Counsel, in their summations to you, may have suggested what the law is. The court again directs you to take the law from the court, even if you have notions of your own as to what you may think or feel it should be. Even if you are dissatisfied with the law, you think it is not good law, or the law ought to be changed, or ought to be something else, under your oaths as jurors, you must take the law from the court. The fact that the court reserved decision at the end of the plaintiff's case, and again at the end of the whole case on the motions of defendant's counsel, must not be taken by you as any indication that the court entertains an opinion upon the facts in this case. This court, for reasons it deems good and sufficient, submits this case to you because it thinks that there is a question of fact to be decided by you jurors. Gentlemen of the jury, this is what is known as the law in a case. And in every negligence case, there are two questions to be considered and two facts that must be proved in order to establish any evidence of negligence on the part of the defendant. The plaintiff, in order to make out his cause of action, as I say, must prove, first, that the defendant was guilty of negligence which caused the accident, and secondly, that the plaintiff, the younger in this case, was free from negligence contributing thereto. It is very proper that the law should so ordain, because the law does not allow a person to recover damages from a defendant for injuries if the negligence of the person injured has helped to bring about the injury, because one cannot recover and should not recover for injuries which he himself has been instrumental in bringing about. Therefore, it does not make any difference how negligent the defendant may have been. If the plaintiff was guilty of contributory negligence, he may not recover anything from the defendant. How's it?
Somewhat fast.
See, 4 into 710 is 1, 2, just short of 180.